Indian Constitution, Article 3. Under Union Article 3, a new state may be formed or established in the following ways. 1. By separation of territory from any state, or 2. By uniting two or more states, or 3. By uniting any parts of states, or 4. By uniting any territory to a part of any state. Parliament under this article can also increase or decrease the area of any state or alter the boundaries or change the name of any state. Article 3 deals with the formation of a new state out of the territories of the existing states. The power to form new states under Article 3(a) includes the power to form a new state or union territory by annexing part of any state or union territory to any other state or union territory. The word state in Article 3, clauses a to e, includes a union territory also. The Indian Constitution empowers the Parliament to alter the territory or names, etc. of the states without their consent or concurrence. It can form new states and can alter the area, boundaries or names of the existing states by a law passed by simple majority. The conditions laid down for making of such a law are, firstly, no bill for the formation of new states or the alteration of the boundaries or the names of existing states shall be introduced in either house of the Parliament except recommendation of the President. Secondly, if the bill affects the area, boundaries or the names of the states, the President is required to refer the bill to the legislature of the state so affected for expressing its views within the period specified by the President. The President may extend the period so specified. If the state legislature, to which the bill has been referred, does not express its views within the period so specified or extended, the bill may be introduced in the Parliament even though the views of the state have not been obtained by the President. If the state legislature expresses its views within the time so specified or extended, the Parliament is not bound to accept upon the views of the state legislature. Further, it is not necessary to make fresh reference to state legislature every time an amendment to the bill is proposed and accepted. Thus, it is clear that the very existence of a state depends upon the suite with the central government. The reason why such a power has been conferred on the Union has already been explained in the preceding chapter. These articles thus demonstrate the flexibility of the Indian Constitution. By a simple majority and by ordinary legislature process, Parliament may form a new state or alter the boundaries, etc. of existing state and thereby change the political map of India. Under Article 3(c), Parliament may, by law, increase or diminish the area of any state. The diminution of area of any state may occur where a part of the state is taken out and added to another state. Parliament has been empowered to cut away the entire area of a state to form a new state or to increase the area of any state. Does the power of Parliament to diminish the area of any state include also the power to cede Indian territory to a foreign state? This question came up for consideration before the Supreme Court of India in a reference made by the President of India under Article 143. The facts of the case are as follows. The Indo-Pakistan Agreement entered into in 1958 for resolving certain border disputes, provided inter alia. 1. For the transfer of one half of the area of Berubri Union by India to Pakistan and 2. For the exchange of old Kuch Bihar enclaves. Berubri Union comprised an area of 9 square miles in the state of West Bengal with a population of about 12,000. When the central government sought to implement the agreement, A powerful political agitation was started against the proposed transfer of territory to Pakistan. Thereupon the President referred the matter to the Supreme Court for its advisory opinion under Article 143. The questions referred to were: 1. Is any legislative action necessary for the implementation of agreement relating to Berubri Union, and 2. If so, is law of Parliament under Article 3 sufficient, or is an amendment of the Constitution in accordance with Article 368 necessary, or both? On behalf of the Union Government, it was contended that the agreement did nothing more than to ascertain the true boundary of India, and therefore, its implementation did not involve handing over any Indian territory but only territory which did not belong to Pakistan, and this could be done in the exercise of the executive power of the Union. The Supreme Court rejected this contention and held that transfer agreement involved cession of territory included in the schedule, and it was outside the scope of parliamentary legislation. The power of Parliament under Article 3 to diminish the area of any state does not cover ceding of Indian territory to a foreign state. Accordingly, the court held that the Parliament had no power under Article 3(c) to make a law to implement the Berubri Agreement, an agreement entered into with the government of a foreign state ceding Indian territory to a foreign state. The said agreement could only be implemented by an amendment of the Constitution in accordance with Article 368. The territory ceded may be a part of the state or union territory. Construing the scheme of Articles 2 and 3, the court held that Article 3 deals with internal readjustment inter se of the territories of the constituent states of India. The area diminished under Article 3(c) continues to be part of the territory of India. Article 3(c) does not, therefore, provide for cession of the territory to a foreign state. Hence, an agreement involving a transfer of territory to a foreign state cannot be implemented by simply passing a law under Article 3. For this, an amendment of the Constitution is necessary. This does not, however, mean that there is no power to acquire or cede territory. The power to acquire and cede territory is an attribute of sovereignty, and India, being a sovereign state, has power to acquire and cede territory both under international law and according to the preamble. Pursuant to the court's opinion, the Constitution, 9th Amendment Act, 1960, was passed for giving effect to the transfer of certain territory to Pakistan under an agreement entered into between the governments of India and Pakistan.